Barbara, can you hear me? Okay, now you have me off.
We can still hear you, or I can.
Ms. Burkett? Barbara? Maybe I was just going to answer a question about monitoring attendance, but she may be off. So I'm going to sign off too. Nicole, are you on the call? She's
Yes,
on.
I'm here.
Okay. I was just wondering what we were
Yes,
waiting.
yeah, I thought we were just waiting for Louisa, so we can go ahead and get started.
No, Louisa has had the trainings.
Yeah.
No, I think she was talking about me for starting the meeting up for the roll call.
Oh, okay. I thought this was information only. Sorry.
Yeah, but I mean, for us, I guess doing the attendance for the individuals who are here on the boards, they're attending the session, so that way we'll know who's here and who's not. So it is now 4:17 p.m. And today is a training session for the COB and the DFOB board members. I'm gonna do the roll call for the COB members that's present. Sierra Cimarral, Derek Kilgore, Harrison Sand,
Here.
Stephen Rovac, Christine Brooks, Bradley Ortega, Jennifer Whitaker,
Here.
Keith Rose.
Here.
And for the DFOB individuals who are here, their names. My eyes are very bad right now. DFOB. Let me fix up right quick. Reverend Gray, James Dom, Hillary Stuck. Oh no, that's not wrong. That's wrong. Arnitha Lewis, Thomas Lawson, Pam Walker. The new names. My list is not updated here. Oh, my goodness gracious. Please bear with me for a minute. We gotta get some new names I have to put out here. And only the. My goodness gracious. Sorry about this. Let's apologize.
This is Jennifer speaking. Can you guys hear me?
Okay, Jennifer.
Yeah.
I'm
I have a
looking.
quick question.
Yes.
I have a quick question. How many COB board members are present?
Right now we have, look like we only have about 3.
I'm here. Derek Hilgo's here.
Oh, you're here? Okay. I didn't hear you say your name. Okay, I'm looking for the.
This is Jennifer again. As the members that's present, is this considered a meeting or just training?
This is training.
Okay,
This is a training session. And,
okay.
um,
All right, thank you. I'm gonna mute myself.
you can mute yourself. Okay, thank you. Looks like I don't have the updated list of the DFOB people on my plate here. Let me find something right quick. Oh, gosh. I apologize, just a minute.
Would it
Louisa, if
be
the
easier
Yeah.
if everyone just put their name in the chat and that way Sergeant Perry can
That'd be nice,
started?
because there's a list I don't have here. Okay,
Okay.
good. Those are the, well, everybody put their name in the chat, please. So that way we can make sure we have the list correct.
This is Keith Rose. My phone says the chat is turned off.
Yeah, chat is disabled.
Oh, it is? Okay.
if it helps, Louisa, if the website's up to date, I have the name of the 9 members from the website, the city
Okay,
website.
I have the DFOB members' names. Reverend Gray, Pamela Walker, James Dom, Tom Lawson, Anita Lewis, Uskami Gay,
Usman,
Usman Gay, sorry about that, and Kanika Hopper.
Present.
Okay, great. Thank you. Okay, as it stands right now, the training session will begin. Nicole Barton, do you want to introduce the individual who's going to be doing the training?
Yes, thank you. We have Sergeant Stephen Perry, who's our subject matter expert this evening, and he's going to deliver national standards of constitutional policing, state and federal laws governing police. And he is an excellent trainer, and we are grateful to have you here tonight, Sergeant Perry. And you have a great group of people on this line who are interested in everything that you have to say. And at the end, we'll have some questions for you as well.
Fantastic. Thank you, and good evening, everybody. Thank you for having me. Thank you for being here and attending the training. My name is Sergeant Stephen Perry. I'll give you a brief introduction. As it stands currently, I am the supervisor of the Community Engagement and Recruitment Unit. I've taught constitutional law for the Police Academy for 6 years. So I know quite a bit. So I was more than happy to take part in this training for Nicole. Really quick, I'm going to share my screen. Sharing is not turned. Oh, so it says sharing is not turned on. I have a presentation to show, which is vital. I mean, I don't want to just talk the whole time. You know. Oh, perfect. Okay. I'll share that. I will. Okay, can everybody see my screen? Okay,
Yes.
perfect. So sometimes when I start talking, I just talk. If at any point you have a question, just raise your hand or just stop me in my tracks and just you can get asked any question. There's no such thing as a stupid question. That's what we tell the recruits. So we're going to discuss 2 sides today. So we're going to discuss the constitutional side of what police are allowed and not allowed to do per se in a way. And then we're going to discuss how it works in terms of places that individuals are incarcerated, such as the Justice Center, detainees basically, and the rights that they maintain, even after being arrested and incarcerated. So again, if you have any questions at any moment, just let me know.
Sergeant Perry, I just want to let you know you're showing us the notes view of your presentation. I don't know if you care if we see your notes or not. I just wanted to give you the warning.
I'm trying to. Let me go back. Trying to think, is this my main screen or Can you see it now?
The notes are gone and we just see the
Perfect.
PowerPoint.
Perfect. Okay, so again, we're going to discuss the constitutional side of what police are allowed to do, and then we're going to discuss the detention facility side of it too. So let's talk about how the Constitution really quick. So the Constitution right now, as it stands, is considered the oldest document federally that's still acknowledged by the federal government. One thing that's important to know is that the way in which we look at the law and we address case law, which is very important, is English common law. So that's the standard that we set, and that's the standard that we abide by at this point when it comes to setting precedents for cases that have happened in the past and how they are used for the future. So if, let's say, for instance, a case happened 60 years ago, whatever ruling that the judge gave in that particular case will be considered precedent. The precedent was set. So if something happens in the future, then they would utilize that same decision that they made 60 years ago. Now, if a case is slightly different, they may interpret it a little different, but for the most part, that same concept would apply. So the Constitution was created in 1787 and ratified the very next year. And again, the reason that I'm harping on the Constitution is because that's essentially the rule book for police. That is one of many. The other rule book that I explain to recruits is that any case law that governs police and how we take action is our rule book if I connect that to, let's say, a sport that we will play. So if you play basketball or soccer, there's rules to the game. Well, case law are the rules that are set for police. So essentially, the Constitution defines the basic rights of citizens in the form of the Bill of Rights, which are the first 10 amendments of the Constitution. And also, let me move this to the side, it essentially defines the way in which the government functions, and it essentially tells them what they can and cannot do. In many ways, a lot of people believe that big government can essentially do what they want to do, which is not the case. They are very limited. Also, any powers that are not reserved by the federal government in the Constitution are allowed to, well, each state is allowed to have certain levels of sovereignty, so they can create and establish their own constitution and their own local rules and laws and statutes within their specific states. Okay, so these are some important amendments that apply to police. Very important things to note, because I'm pretty sure when things are of a concern, these are the amendments that they would apply to. So the first one is the First Amendment, which protects both religion, speech, press, peaceful assembly. So prior to 2014, this is not something that was a huge thing in this region. One thing that was never really addressed was civil unrest and civil disobedience. This region had never experienced it before. So when we did, and police made a lot of mistakes, we had to correct those mistakes by way of training. So we had to explain the parameters of the First Amendment and how they apply, and how we, as police, we have to respect those. One would be religion, which means that anybody can exercise whatever religion that they choose, whether that be Christianity, if somebody chooses to be whatever. I even tell the recruits that if somebody wants to praise SpongeBob, they can. That's their choice. We cannot infringe on that right, okay? When it comes to speech, for the most part, I would say 90% of speech is protected. The only speech that is not protected is hate speech and threatening speech. So we can't threaten to commit any felonious act towards somebody, which would technically be a crime. Freedom of press, so any individual who is a member of the press has the right to be present at any scene of any incident, and they have the right to report whatever it is that they see and observe. When it comes to peaceful assemblies, anybody can peacefully assemble anywhere that they choose. It gets a little sticky sometimes when it comes to unlawful assemblies, which at that point, statutory law would apply if there is some form of criminality involved. So the statute says that if 6 or more people were to assemble in a specific place and threaten to violate state or federal laws by way of force or violence, technically that would be deemed an unlawful assembly. For police, I would imagine every agency, I can't quite speak for any other agency, but I would imagine they have protocols in place that if they were to encounter a group of people who they deem is unlawfully assembling, they would have to have certain protocols in place to provide warnings and to give free passage to leave if people are asked to leave, etc. So those are all protected rights. And as police, we have to understand and respect that. We also have to understand the way in which that applied to police. So, for example, speech. Some policemen may not agree much with the way speech is used toward them, but we explain to officers that, hey, listen, your peace cannot be disturbed. So you cannot say, hey, listen, I don't appreciate what you said to me. That may be the case, but we cannot arrest somebody simply based on words that they use unless it is threatening speech. So that's the First Amendment. I want to say the Fourth Amendment is by far the most important because it's the most litigated out of all of them, and it's the most, I guess it's highly interpreted when police take action. So the Fourth Amendment, the biggest highlight from the Fourth Amendment will be unreasonable search and seizure, which essentially says that the police cannot unreasonably search somebody's person, their vehicle, or their home, apartment, condo, etc., without some legal justification to do so. Now, if your search is reasonable, then it is allowed according to the law. However, if it is deemed unreasonable, as interpreted by any attorney or any legal body, then it would have some civil rights implications. The second half of the Fourth Amendment, which is also equally important, is the fact that warrants to search people, vehicles, homes will not be issued unless the police officer establishes some form of probable cause to believe that there's a specific crime being committed and there is a piece of evidence or there's an item inside that we need to acquire right now. That will most of the time they will come in the form of an affidavit with a magistrate or a judge. And if the judge and the local attorney's office agrees with the request for the search warrant, it would be granted, signed, and then they would then take actions to execute said search warrant. The Fifth Amendment, the biggest portion of the Fifth Amendment talks about self-incrimination, which means that nobody is obligated to be a witness against themselves, and we cannot compel them as law enforcement to be a witness against themselves, meaning if asked questions, they can remain silent. So there's two big, I'm pretty sure everybody in this meeting has heard of Miranda rights. Okay, so Miranda has two very specific amendments built into it, both Fifth and Sixth, which we'll talk about in a minute. The Fifth Amendment talks about self-incrimination, so the right to remain silent. So if a policeman were to question somebody, the individual that they're questioning, it could be a potential suspect, a witness, even a victim, can technically remain silent and not speak to the police in any form or fashion. So, and which is acceptable, and every policeman accepts that reality. And for the most part, we wouldn't imagine that a witness or a victim would remain silent, but they have the right to do so. For the most part, it would be somebody who was accused of a crime. And of course, again, we cannot compel them to be a witness against themselves, which is very important. The Sixth Amendment, the biggest portion of that is the right to counsel. So anybody who is accused of a crime, whether it's somebody who was affluent or somebody who lives in a very poverty situation in their life, has the right to an attorney free of charge in the form of a public defender. So we know that to retain private counsel can be very expensive sometimes. We have to provide them with some legal counsel to protect them throughout the criminal justice process. Last but not least, another important amendment for police is the 14th, which talks about due process. Now, technically, due process is built into the Fifth Amendment. However, due process wasn't attached to the individual states until the 14th Amendment was adopted. So it also talks about equal protection under the law and the citizenship clause, which is important when it comes to undocumented immigrants, because of course, if you're born in this country, you're just a naturalized citizen based on that. So just note those in the future if they ever come up and are ever an issue. Let's talk about probable cause. So probable cause is very important. Why is probable cause important? Probable cause and reasonable suspicion is important because this is a tool that law enforcement utilize on a daily basis, literally. It is very important, and this is something that I harp on a lot for young recruits who are becoming police officers to not just remember a definition and memorize it. What's important is to know how to apply it in reality. Okay. Anybody can remember and regurgitate a definition, but can you apply this practically? So I provide definitions for both. Probable cause is defined as facts and circumstances which would lead a reasonable person to believe that a crime has been committed and that a particular person or persons committed said crime. So in order for a police officer to lawfully arrest somebody custodially, meaning completely strip them of their freedom to move and leave and walk around, we must first establish probable cause. So the way that I explain probable cause is anytime something happens, I look at it like a puzzle. Okay. And so upon arrival to any type of scene, you have to take puzzle pieces, put them together, and then ask yourself, do I believe that a crime was committed? One. And two, do I believe a certain person committed that crime? Okay. If the answer is yes to both, probable cause would exist, and then they can, at that point, make an arrest. Okay. A lawful arrest. Now, reasonable suspicion, on the other hand, which is equally important in my eyes. Yes and no. It's defined as specific and articulable facts which would lead a reasonable person to suspect that criminal activity is afoot. Reasonable suspicion is important because this is the legal concept or the legal rule that allows police to lawfully detain an individual to investigate a crime that they suspect is afoot. Okay, this was established with Terry v. Ohio back in 1968, a very long time ago. So if based on whatever circumstances are present, that a policeman makes certain observations, speaks to certain witnesses, and they discover any type of evidence that would lead them to suspect that some crime is happening, okay, then they can then take action toward the individual who they suspect is involved in some capacity. Okay, now this only would allow a temporary detention, which we'll talk about in a second, for that policeman to investigate that crime that they suspect is happening. In that time period, which has to be a reasonable amount of time to detain this person, that we have to do whatever we need to do to investigate this to either dispel my suspicion or to prove my suspicion. Okay, if we prove the suspicion, then at that point we reach the level of probable cause and we make an arrest. If we dispel my suspicion, then at that point we would just release that person and let them go free. Does that make sense to everybody? I hope so. And I don't want to talk too fast. I promise I don't mean to talk too fast if I am. So let's talk about the three types of citizen contacts, which are very important for police officers to understand as they go from the academy to entering the streets. So we talk
Sergeant
about three
Perry.
I'm sorry.
Hi, Sergeant Perry.
Yes.
For me, you're speaking really, really fast, and I'm trying to grasp this.
Okay.
But will these slides be available to us?
I can send them. Yes, I can provide it if I need to.
Okay, that's fine.
I just didn't know how much time I had because I know I lost like 20 minutes. So
I hear you.
I didn't want to speak too fast, but I didn't want to speak too slow either. But I'll slow it down.
Okay, thank you.
So I teach the recruits that we have three types of citizen contacts, which are very important for them to know, and they need to understand the justification for each one. Okay, so we first talk about consensual encounters. Now, consensual encounters is something that a police officer may do on a daily basis. We meet a lot of people. Okay, at some point while on patrol, doing what they do every day, a policeman may observe a certain behavior from a specific group of people or a certain person that creates a certain hunch for them that some crime may be occurring or is about to occur, or they may have something that we call mere suspicion. So mere suspicion and or a hunch would not justify a detention lawfully, which is a Fourth Amendment seizure, okay? It has to be a reasonable seizure in order to justify it and not be a civil rights violation under the Fourth Amendment. So if I, as a policeman, have a hunch that a crime is being committed, or I have mere suspicion, then I can do what's called a consensual encounter. So let me give you an example. Let's say we get a call from a citizen that says there's a guy standing on the corner. I don't recognize him from the neighborhood. We think he may be selling drugs. He's been around for a while. The person decided to refuse contact, which means they don't want to speak to the police again. They give a vague description of an individual in all dark clothing. Okay, it's very vague, very vague. With just that information alone, a policeman may only have what's called a hunch to think that this person is involved in some criminality. So they would just approach them freely, okay? During this encounter, I cannot put this person in a position to feel like they are detained or they are not free to walk away from me, okay? Which means I cannot restrict their movement in any way, and I cannot demand anything from them. So for example, if this is a consensual encounter and I want to conduct a frisk of their outer clothing to see if they have weapons, I can't demand that they put their hands on my vehicle or put their hands on the wall or sit down or put their hands on their heads. I have to ask, do you mind if I pat you down for my safety? They can easily say no, and if they do, then that's completely their right to do. Even if they say, hey, listen, I don't want to talk to you, they can freely just walk away at any moment if it's a consensual encounter. Now, if it's a brief detention, that means that as a police officer, I have established reasonable suspicion, just like we talked about, and I want to detain this person briefly to investigate my suspicion, okay? Again, I can only stop this person for a reasonable amount of time. I just need enough time to investigate my suspicion. I cannot hold this person unreasonably. Okay, nor can I move them around too much. We have to be careful with that Fourth Amendment when it comes to the movement of people we suspect that are involved in crimes. Okay, I cannot take a suspect from one place to another and I don't have probable cause yet, because that may be deemed an arrest by virtue. Okay, I'm handcuffing the subject, I'm frisking them, putting them in the backseat of my vehicle, I'm driving them to another street. That could be an issue in terms of the Fourth Amendment. So we want to be real careful. If we need this person identified by a victim or a witness who alleged that they committed whatever offense, then it's probably best practice to bring the victim or the witness to where this alleged suspect may be. Okay, that's probably the best practice to do. Again, if my suspicion is dispelled, I will let this person go free. Okay, if my suspicion is proven, then I will then establish probable cause and make an arrest, okay? After that, we have custodial arrest. So at this point, I have established probable cause to believe that this person committed the crime alleged, and we are going to completely strip them of their freedom to leave, okay? Which means that we are going to handcuff this person, conduct a custodial search, and then take them to any area station that we deem necessary, okay? Based on wherever we are in the city. So again, those are the three citizen contacts. Again, for consensual encounters, we need a hunch or a mere suspicion. That person is always free to leave at any moment. And again, they can always remain silent. They don't have to assist us at all. With a brief detention, that means that I've established reasonable suspicion that I suspect their criminal activity is afoot. This person may be involved, and I can only stop them for a brief moment. And the movement of this person is limited. Custodial arrest, I've established probable cause to believe that this person has committed the crime alleged, and I would completely strip them of their freedom and take them to the area station. I hope I slowed down enough for that one. So let's talk about how the law works. Okay, let's talk about the criminal process really quick. So if somebody calls 911, they're probably calling to report a crime. Okay, it is my job as the police to respond and to assess what's happening, okay? When I arrive, I'm probably going to speak to a victim or a witness. It's also my job to decipher which one this person is, okay? Now, if this person says that this crime was committed due to XYZ, okay? So it is my time. At this point, I need to conduct what's called an investigation. Use my skills that I learned in the police academy and based on my experience as a law enforcement officer, take this information, this statement, collect whatever evidence I need to establish first that a crime was committed and if a specific person committed that crime, okay? While I'm investigating, I'm speaking to victims, witnesses, and possibly suspects, okay? I'll also view video surveillance. I'll look at evidence that was dropped, anything that is deemed connected to this specific incident that I will investigate, okay? Now, if based on an investigation, I'm led to believe that a crime was committed and this person did it, I will then make an arrest, okay? I would take the person into custody, fully taking away their right to leave to answer to a criminal offense, okay? Whatever that is alleged. Now, understand that when it comes to probable cause, that is a very low standard of proof. It is not difficult to establish probable cause, okay? So when it comes to probable cause and proof beyond a reasonable doubt, those are on two very different ends of the spectrum, okay? Now, when you think about probable cause when it comes to arresting people, I want you to think look at it like this. If the probability is higher that this person committed this crime, then they would be arrested. If the probability is lower, then they won't be arrested, okay? Keep in mind, based on circumstances, sometimes innocent people can look like they committed a certain crime. It can happen, and it has happened, okay? The goal of the criminal justice system is to sort out that this person is innocent of any wrongdoing and we can let them go. We hope to sort that out during the investigative process. The goal is to never take anybody innocent of anything to jail at all. However, there are times where people may accuse somebody of a crime that they didn't commit, and based on that person's statement, we would have to make an arrest. Okay, so just kind of keep that in mind. From there, we take them to the station to be booked, which is a separate process, but we essentially take property from them. We conduct a search. We take their property, seal it so it can travel with them wherever they go. And then we do any administrative function like take their names, addresses, social security numbers, date of birth, etc. We make a record of arrest for this person, okay? Now, if this person was arrested for, let's say, KPS warrants, bench warrants issued by the city, the 24-hour rule would not apply to this. Let me explain what the 24-hour rule is. If somebody is arrested for an original misdemeanor or a felony, state charges, this is the first time they got arrested for this crime, the police have 24 hours to have warrants issued by the circuit attorney's office against this person, okay? If beyond that 24 hours, that person would be released automatically. Anybody that we take into custody, we have to lawfully justify why this person is being incarcerated, and the circuit attorney's office, in connection with judges, would make those decisions based on whatever information we present to them, okay? So within that 24-hour span, we respond to the warrant office, which is downtown, Mill Corner Head Courthouse. We speak to an attorney. We explain to them what happened and the circumstances of the case. They would then make an informed decision legally if they will proceed, which they would issue the case against this person. They would stop it right there, which they would refuse the case based on whatever circumstances, or they would do what's called take it under advisement, or TUA, which means that we're going to pause it for now. There's probably more information that we need that you don't have with you right now. When you get that, bring it back. We'll reevaluate and reassess. If we believe that there is enough to go forward, then we'll issue the case. If not, we'll refuse it and it will stop right there. So let's say for this example that the case was issued, they want to take it forward. They have to see a judge within a 24 to 48 hour period. So anybody that's incarcerated, they've been formally charged at this point. So they then turn from a suspect on the street, they got arrested, they become an offender. Once they're formally charged, then they become a defendant, okay? So that defendant must see a judge at the initial appearance within a 24 to 48 hour period, okay? At this point, the judge will inform them of very specific things that they need to know, such as what they were charged with, possible penalties. They would then provide them with an attorney at this point, and if there's any bail, that would be assessed at that point, okay? And they'll let them know of the next court appearance.
I have a question.
Yes.
Is it 24 or 48 hours? And if they don't see a judge within that time frame, what happens then?
So if they don't, if they don't see a judge in that time period, then it they almost have to. There's never a situation on a misdemeanor or a felony that they don't see a judge. If it's a misdemeanor, odds are the circuit attorney's office issue what's called a misdemeanor summons. So that person would probably just be released automatically based on that because it's a low-level violation. If this person is a habitual offender, then they would have to assess if this person is a flight risk or a danger to the community. If it's for a felony, it would just kind of depend what it is. But odds are, if they're a first-time offender, it's a low-level felony, they'll probably be released on their own recognizance. If it's a very serious felony, a judge would have to assess bail or even release. So there's never a time where they won't see a judge for a misdemeanor or a felony. They have to. It's a part of the process. They would almost have to. But there is no specific number, if I'm not mistaken. I mean, if I could be wrong, but from my understanding, it's within a day or at least 2 days. I could be wrong. I can find a specific answer for you if I need to.
Thank
Did
you.
they answer your question?
Yes.
Okay. So after the initial appearance, they would have to make a decision if that person would be held at the Justice Center without bail or if that person would be released. So the next court appearance will probably be a prelim or a grand jury. Now, it is ultimately up to the state to decide if we're going to a prelim or a grand jury. They're both technically designed to do the same thing. They have to determine if probable cause exists in this case, okay? Now, a preliminary hearing is typically utilized when the state is the victim. So, for example, if somebody is charged with unlawful use of a weapon, the state would be the victim in that case. The state would prosecute, essentially, or they would act for themselves. If, let's say, for instance, that person was arrested for violation of Missouri Controlled Substance Law, like possession of a controlled substance, that's a state crime. They would probably go to a prelim for that, which is like a mini trial. The only people present for a prelim would be a judge, prosecutor, the defense attorney, the defendant, and any witnesses that are called to the stand by either the prosecution or the defense. One thing that's important to note is that the person that's on the stand, any witness is subject to cross-examination, okay? Despite who they're called to the stand for. At that point, after hearing all the testimony necessary, the judge would then decide if probable cause exists. If so, they'll file an information and then bind this person over for the next proceeding. Now, if we go to a grand jury, the grand jury is more of a secret meeting derived of the prosecutor and 12 members of the jury and an alternate for the most part. So the policeman will respond. The people that are not present is the defendant and that defendant's attorney. So the policeman would respond, swear in, and be asked to provide the details of the case. After they provide the details of the case, they would then be released from the room. The grand jury would convene. They would make a decision if probable cause exists. If it does, they would then issue an indictment for that person, or what they call a true bill. Okay. If an indictment is issued, that means that we are going forward in the criminal justice process. Okay. So let's say that's the case. We're going forward. They have to get what's called a trial arraignment, which means they have to enter a plea of guilty, not guilty, or no contest. Okay. It is at this point or in this process that plea bargaining starts. Okay. From my estimation, I would just imagine that the circuit attorney's office pleads maybe 85% of their cases. Okay. However, they probably take the most cases to trial in the region. The most people decide to go to a trial by far in any portion of the region. So if a person says they want to enter a plea of not guilty and they want to take it to trial, then we'll take it to trial. Okay. But if they do take a plea deal, it is at this point where they would arrange that and they would enter a plea of guilty. Okay. So let's say this person wants to enter a plea of not guilty, then we go to a trial. Okay. Again, keep in mind that at this point, it is a burden of proof on the state to prove the case beyond a reasonable doubt, which is not a very easy thing to do. Essentially, they have to convince 12 people on a jury and firmly convince them that the defendant committed the crime alleged against them. Okay. This is by way of statements made by victims and witnesses and evidence. Okay. This evidence can be DNA, video surveillance, body cam footage, etc., fingerprints, blood evidence, etc., etc., etc. Okay. If the state proves the case beyond a reasonable doubt, then they would get a guilty verdict, and at that point, the judge will take over from there and provide sentencing. Okay. So what happens after I'm incarcerated? So anybody that is arrested by the police in this city, at least, for any misdemeanor or felony for a pending case after being formally charged would be housed at the St. Louis City Justice Center. Okay. They would either remain there or they can bail out. Okay. And they would all be awaiting trial. So understand that there are times where people can sit in the Justice Center for years, not just days, not just weeks, not just months. We're talking years. Okay. And this person hasn't even been convicted of a crime yet. So just imagine the fairness in sitting in a jail for 2 years and I haven't even been convicted of a crime yet. Okay. Now, of course, that would ultimately come down to the type of crime you were arrested for. If it is something such as a Class A felony, murder, rape, sodomy, robbery, first degree, assault first degree with a serious physical injury, child molestation in the first degree, trafficking, narcotics in the first degree. These are very serious crimes in this state. So we take that very serious. So does the criminal justice system. So in that case, yes, you may have to kind of sit for a little while. But any kind of low level crime, if this person is not a habitual offender, or if this person is not a persistent or a prior offender, I think we can. I think a lot of times the circuit attorney's office has a conversation of, hey, listen, maybe we can just do a monitoring system or release this person on their own recognizance so there's not an overcrowding issue with the Justice Center. Let's talk about rights. So rights don't just go away when you get arrested. Okay, we'll talk about the ones that remain, but they don't just go away completely.
Excuse me, Sergeant Perry.
I'm sorry, yes.
Can I ask a question? Why would it take years for a trial to come up for someone?
That's a great question. So let's say somebody is arrested for first degree murder. There's a lot, and an attorney at the circuit attorney's office can explain this a lot better than I can, and I don't like to speculate, but let me just provide my personal opinion. This is just my opinion, the opinion of no one else. So if somebody is arrested for a crime such as first degree murder, that takes a lot in terms of preparing for a criminal trial. So when it comes to evidence collection, when it comes to continuances, when it comes to acquiring the witnesses that are involved, when it comes to any legal parameters or any legal remedies that the defense attorneys can make, like we have suppression hearings and filing motions of discovery so I can get the evidence against my client, etc. If the prosecutors are not ready for trial, they may file for a continuance, and that continuance may be like another 90 days, etc. With all of those rules that are in place that allow the movement of the legal system, sometimes it can be pushed out to about a year and a half, maybe 2 years sometimes. So it's just a lot of legal movement that is allowed for both the defense and the prosecution to kind of prolong the time of their incarceration, I guess, at the Justice Center.
So if a person isn't guilty, are they compensated in some way for spending time in prison for a year and a half or 2, or they just get released?
They just get released. There's never a time that somebody who's incarcerated at the City Justice Center for a particular alleged offense, who, let's say they're found not guilty, no, the criminal justice system won't compensate them. No.
Okay, thank you.
At least not in
I
Missouri.
was just wondering, I'm kind of new to everything, so appreciate that.
No, for sure, absolutely. That was a great question, actually.
I have a question, Sergeant Perry. I have a question.
Yes.
Kind of piggybacking on both of those questions. I do understand how the time frame, the time may be extended based on something like, in your example, the murder trial, where there will be continuances, but that at least that person has seen a judge. But if we have, and this is just a question, if we have like a 24 to 48 time frame for a person to see a judge, why isn't there some type of tier on, let's say, based on the type of offense that they're being charged for? Why isn't there some type of tier of when this person may see a judge? Let's say it's not a murder. Let's say it's theft or burglary or something like that, something that's nonviolent. I hear you saying that maybe they'll be released on their own recognizance, but maybe they've done it 2 or 3 times. But why are they sitting in jail for 2 or 3 years and haven't been to trial? Shouldn't there be something built in for that?
So there's never a time where anyone would sit in the city's justice center for a low-level felony or misdemeanor for 2 years without
Okay.
any plea deal or trial. The only types of crimes that take time to get to are very serious felonies. So
Okay.
again, murder, manslaughter, rape, sodomy, those are very serious offenses. Those are situations where somebody may sit in the justice center for about 1.5 years, 2 years, 3, etc. Any low-level felonies, they would probably sort that out very quickly. They don't take very long at all. I think if that person takes a plea deal, it'll end even faster. The judge would assess a penalty, or they would agree to some penalty. The state will, and they'll say, hey, listen, well, you've been charged with burglary in the 2nd degree. We have this evidence against you. You're considered a prior offender. You were already a convicted felon. It's probably best that you take a plea deal, and we'll offer you 2 years in prison. They'll probably say, cool. And they've probably reached that decision in maybe 6 months, 4 months, versus sitting in jail. Now, somebody who wants to fight a trial, and again, it's a very serious offense, they're going to just hang out. They're not going to just plead guilty to a crime that they didn't commit. They're going to hold on to their innocence, which I don't blame them. I expect somebody to, if they claim their innocence, you fight it in trial. Don't just take a plea deal because you just want to get out. I get how terrible it can be to even just be incarcerated, period. I understand. I completely understand. However, no one should ever just say, I'll give away my freedom just to get out. Like, no, you should never do that. But again, to go back to your question, typically only serious incidents would sit for that long. When it comes to that initial appearance, seeing a judge within that 24 to 48 hour period, if it's a low-level crime, they'll probably be released. If they're a prior or persistent offender, they may be placed on a monitoring system. So they may get an ankle monitor so we can track them. So
I hear you. All right. Thank you.
absolutely. So when it comes to rights, those are guaranteed by statute and the Constitution federally. But when it comes to privileges, however, those are controlled by the facility. So for example, the Justice Center may allow detainees to get certain privileges such as commissary access, visits, recreational time, time in a library, etc. Those privileges, with those being controlled by the facility, they can be taken away. How can I say this? It should be an established rule that the detention facility sets the rules and gives it to the detainee in writing. These are the rules. If you violate the rules, this is the punishment for said rules, and these are the privileges that can be stripped away from you. These are privileges are not guaranteed by law. So if it's a privilege, they don't necessarily have to give it to you. Again, it's controlled by the facility themselves. However, the hope is that they have policies in place to explain to detainees how you are stripped of your privileges. So those are rights versus privileges. The 8th Amendment is very important. So I discussed this with the recruits, but it more so applies to detention facilities versus policemen. Typically, when we arrest somebody, when we're done with them at the holdover at the station, which is technically a detention facility, but is a very, very, very limited and temporary detention facility. Most people don't sit at an area station for more than 2 or 3 hours. From there, they're taken down to the Justice Center as soon as they can go there. So in some aspect, it does apply to them. However, it more so applies to detention facilities when there's a long-term stay, such as correctional officers who work at CJC. So one big thing about the 8th Amendment is protection from cruel and unusual punishment. Now, again, the Justice Center is not designed to be super long-term. However, there may be a case where they are there for a little bit of time, or even if they're serving time on a misdemeanor, because if somebody is convicted or they plead guilty to a misdemeanor, they would serve their time in a city jail. Well, they may serve 9 months on a misdemeanor in the city jail, which means that they're going to spend a lot of time there. We want to make sure that their treatment is humane. We don't want to treat them inhumanely, because they are still people. Even though they are incarcerated, that's not a sentence to say, hey, listen, I can treat you however I see fit. That's not the case at all, okay? So we always want to maintain that protection from cruel and unusual punishment, and to make sure we are monitoring how these detainees are being punished, if they are, internally. We also want to make sure that there's no informal punishment. So it may not be a punishment that's on the books, but there may be a punishment behind the scenes that's delegated amongst the staff that no one really knows about. Okay, these are things that we want to continue to look into to make sure that we are treating these people fairly in the essence of the law. Another one is excessive bail amounts. That's normally dictated by judges. A judge normally sets the bail amount when it comes to that. So that's not excessive in the city. That's not a thing that we even deal with. Typically, if it's a high amount, it's probably justified based on the crime that was committed and if that person is a flight risk, or again, a habitual or persistent offender, the bail amount may be high if it's a very serious crime. Typically, if, again, like I said, if this person is a first-time offender, they'll probably be released. If not, they'll be placed. It'll be a small bail, and they can probably afford 10% of it. The rights that they maintain, which is very important, is the right to exercise any religion that they choose to. Even if this person is incarcerated for however long, they can practice whatever religion that they choose to. Freedom of speech, again, freedom of speech is limited to the point that if it is violent speech, like it may incite a felonious response from someone, or it may lead to some form of violence, I would imagine that the detention facility has the lawful right to curb that speech. If it's letters or gang signs or something like that, that may be an issue for the facility, because it can place everybody in danger, which would include detainees and staff. The right to not to be a witness against themselves, which again goes back to that self-incrimination. So people can be accused of crimes that they allegedly commit while being detained inside a detention facility. Even with that, they have the right to remain silent. The right to an attorney, once they have established a public defender, they maintain that same public defender. The right to bail, so we can't strip them of that unless there's a lawful right to do so. If a judge decides to deny bail based on, again, this person being a danger to the community, or it's a very, very serious offense that this person committed. The right to face their accuser, so anytime this person is accused of a crime, they have the right to face that person. And of course, due process. Due process is extremely crucial. We cannot violate that, meaning we cannot jump steps in the criminal justice process. We have to allow the due process to work its way out. We cannot just say, hey, listen, and this is a very far-fetched example, but let's say somebody committed a crime on the street, and the next day we just decided to incarcerate that person for 6 years. We just skipped so many steps in between that we violated due process for this person. So we have to make sure that we maintain that as well. Of course, clothing. The detention facility has to clothe these individuals. They have to provide nourishment in the form of food and water at the bare minimum for them, and of course, medical treatment. So anytime somebody is incarcerated, we take on, or I guess the detention facility takes on the responsibility of that person if they need to be treated medically in any way, whether that person has a terminal illness, whether this person was injured in any way, they have to provide medical treatment to that person. They cannot deny them of that. The legal standard when it comes to any civil rights lawsuit committed by state actors, we'll talk about that. So anytime somebody alleges that a police officer or a correctional officer violated their federal rights, federal civil rights, they can be sued under Title 42, Section 1983 of the United States Code, that says that, hey, listen, my rights were violated by this state actor in the form of police, or any kind of facility, anybody that works in a detention facility, like a correctional officer. And this person violated my rights under the color of law, which means that they were under their authority or utilizing their authority when they violated this person's rights. So if they were to be sued federally, this is the section that it will fall under if that were to happen. Last but not least, let's talk about some holdover operations for the police department. So again, we have 3 area stations and we have 3 holdovers in each. What if we have a holdover in each station? So these are just some rules to understand when it comes to that. So a holdover is designed to just be a temporary situation for them. So if they are arrested and brought to the station, they are there to be booked accordingly. They are there to be interviewed by detectives, by police, etc. But they can only be there for a certain amount of time. Okay. We want them to go down to the Justice Center to be fully processed and as swiftly as possible. Okay. The max time to be in any holdover with the police department is 8 hours. I'm not sure if there's any exceptions to that specifically. I can do some research on that, but typically the max is 8 hours. I think a lot of times there could be some issues with that. We can get close to that 8 hours sometimes when they close the Justice Center, which happens quite often. I'm not sure if there's a max time as to how long somebody has been at the area stations, but the issue is that things that the Justice Center can provide, we can't. We don't feed them. If that's an issue and they've been incarcerated or detained at an area station for a while, they will probably go get food down at the Justice Center to bring to these individuals in order to keep them fed while we house them. And before they reopen the Justice Center, we can bring detainees downtown. Juveniles are never placed in any holdover in the city. That is individuals who are under the age of 18. So if you are 18 and older, you are considered an adult under the law. However, if you are 17 and younger, you are considered a juvenile. If you are ever detained for any long period of time, it is either at the juvenile detention center or, well, you'll never be held at the station for a long period. If that's the case, you're probably being ex-booked and they're calling your parents to come get you. So you'll never be held a juvenile will never be held at the station for too long. If they're going to be held for some time, it'll be at the juvenile detention center. Same-sex prisoners are held together. So males with males, females with females. If it's a situation about transgender, they will probably be placed alone by themselves in their own cell to kind of keep them safe and keep everybody else safe. Combative prisoners are placed by themselves because they may not only fight police or correctional officers or staff at CJC, but they may also assault inmates. And we don't want that to happen. So to keep everybody safe, we would just kind of put that person by themselves. And all prisoners are subject to full custodial searches by the same sex officer. So ordinarily, males will search males, females will search females. If it's a situation where there is a transgender individual, then technically by policy, they get a choice of what makes them more comfortable. They prefer to be searched by a male officer or a female officer. I think that concludes my presentation. Does anybody have a question for me? I know there was a lot to digest and unpack, but yes. Anyone? Yes. If you have a question.
I have a question.
Sure.
Jennifer again. I'm sorry, it just takes me a minute to digest things.
Okay, that's fine.
When you send the presentation slides, is it possible that you can send the policy or the policy number or whatever it is that the officers are reading so that we can look at what they're reading in conjunction to what we're seeing to make sure it's like in line? That, yeah, I would like that.
Sure, absolutely.
Thank you, Officer Perry.
Mhm.
And you've done a great job. Thank you.
Oh, thank you. I appreciate it. Does anybody else have a question?
I don't know
Yes.
if you can hear me. I have a question.
Yes.
So recently, one of the county officers was charged with taking the cell phones of particularly young women and getting nude photos.
Mhm.
My understanding is that the cell phone has to have, like any other property, you have to have a warrant for that. Is that not true?
Without consent, yes, that's true. You need a search warrant to go into someone's phone without their permission. Yes.
Hi, Sergeant. I got a little lost at one point, and I would appreciate if you could elaborate for me.
Yes.
How do you at the academy train officers on the difference between a warrant and a wanted, and how are those approached differently?
That's a fantastic question. So we explain it in the way in which we have to completely separate the two because they're technically two separate things. So let's talk about warrants. So we explain to them that warrants are issued by judges, magistrates, and no one else. Warrants can be in the form of a capious warrant or bench warrants issued locally here with an ordinance. So essentially what a warrant would be is that, hey, listen, let's talk about at-large warrants. So if somebody allegedly committed a crime, let's say they're not present at the time that we take the report, but let's say it's a domestic violence issue and a young lady called to say, hey, listen, my ex-husband assaulted me at my home. If she provides me with enough information, then I can take that information, write a report, and apply what's called at large, which means that I would speak to an attorney. If the attorney agrees, they would then issue an at-large warrant for that person in connection with a judge, meaning that an attorney, we have legal permission to arrest this person and take them into custody. It's not just, I don't want to confuse you, but it's not a wanted, which is issued by police. So a warrant is issued, a warrant takes away the complication of what a policeman's concept of let's detain this person is versus an attorney and a judge. It's way safer to apply for cases at large versus to issue wanteds. So let's talk about the wanted situation. So if I, on the flip side of that, same situation, a young lady reports that her ex-husband assaulted her at her home. Instead of applying at large with the circuit attorney's office, I put her ex-husband out wanted for questioning, which means that I'll contact a criminal justice agency that we use. It's called Regis. We utilize, I'm pretty sure everybody's familiar with the Ellie Webb, Regis, Mules, and CIC. So we'll contact TRS and they enter this for us. We'll say, hey, listen, this person committed this crime. We want to put them out wanted. The issue with wanted, now mind you, technically, in order to issue a wanted, the policeman has to have some form of probable cause to believe that this person committed this crime, which in this particular situation, that's the case, based on the statements of the victim. That's enough to arrest this person, okay? The issue is that if I put this person out wanted, one, it never expires, which can be problematic because I could have been wanted for 8 years and never have known, which that's an issue. Also, if this person is, let's say they're contacted or stopped in some other jurisdiction, let's say they were stopped in Creve Coeur, and Creve Coeur decides to want to take this person into custody, and let's say something happens where this person was assaulted by the police or they resisted arrest and this person was injured, the suspect was injured, had to go to the hospital, etc. Some things happened. And let's say when Creve Coeur decides to confirm the wanted, let's say for some unusual reason, we The one that didn't exist, we just forgot to cancel it out the system. Okay? Well, that can be very problematic legally for Creve Coeur because they took somebody into custody. They got into a fight with them. They had a resisting. They took somebody into custody that's no longer supposed to be wanted. Not only that, they don't even know the circumstances of the case. So they're arresting somebody, technically, handcuffing, searching, taken to the station. That is an arrest based on knowledge that they have no idea about. They don't even know the circumstances of the case, but yet I'm taking this person into custody and accepting the civil liability of what could come from this. So wanteds legally are very complicated and can be problematic. Warrants are much safer and is really constitutionally the way in which that's the way things should kind of be. So for example, well, I don't even want to use an example. I would just say that whatever wanted system we have, instead of even doing one, as in, again, this is my personal opinion, I cannot speak for the police department. If the same information you have for the wanted, you should just apply it at large. That's a much safer thing to do because you're letting the liability go because this warrant is issued by a judge, which is very safe for any police agency. So I hope that answered your question. Did that answer your question? I kind of go down a rabbit hole sometimes.
Yeah, that was really informative. Thank you.
Okay. Does anybody else have any questions?
Yes, briefly.
Yes.
So in cases where the warrant was not rescinded or it should have been taken away, I don't know what words to use. I'm new to all of this.
Mhm.
And it is an error of the police department, the courts, or whoever it is, where does that lie for the person that's being arrested?
It's going to end in probably some civil litigation. They may file lawsuits, which I would understand. For example, if somebody's arrested for what we saw is active warrants. Let's say I arrest somebody because they had active bench warrants, but when we go to book them, we find out that these warrants should have been canceled out of the system. It could have been some clerical error by the courts, municipal courts. It could easily be a clerical error that no one saw. It fell through the cracks. As police, we acted on good faith. We were under the impression that they were active, but it's ultimately going to end with probably some civil litigation.
So what does that mean for the current charge that the police officer tried to, I guess, get the person on?
That's a great question. So let's go back to that Creve Coeur example. Let's say they arrest this person because in their system, these warrants were active. Okay.
Yes.
So they take that person into custody. It leads to a fight. They charge him with resisting arrest. Excuse me. Well, let's say Creve Coeur later learns that these warrants were no longer active. They were still acting in good faith, legally and constitutionally. They were acting in good faith. However, this person technically resisted arrest. Let's say they assaulted a policeman. The assault on the policeman would still be in play because the police were acting on good faith. So that the assault on the policeman doesn't just go away because technically the warrants were never lifted when they should have been. If that makes sense.
It makes sense, but had it not been for the error of the courts, they would not have stopped that particular person, let's say, and there wouldn't have been a assault on the police officer.
Understood. You are absolutely right. That would ultimately be up to the prosecuting attorney. So, for example, Mr. Circuit Attorney Gabe Gore or what was Circuit Attorney Wesley Bell, whoever takes that on, they would have to address that to say, hey, listen, well, based on our error or the area of the error of the police department, we can either drop this case or proceed. But again, I totally understand what you're saying. That's a very good point. However, they would probably ultimately look at it as if, well, the police were acting in good faith. They saw something that they thought was active and valid, and then one of their colleagues were assaulted, were slammed, or whatever the case may be, punched or whatever. I doubt, and this again, it's my personal opinion. I can't speak for the Circuit Attorney's Office or the police department, but in my personal opinion, I would say that the original charge will go away, but the assault would still be pending because that's just kind of what it is. They would be essentially because they were acting in good faith legally.
Okay, fair enough. And this is my last question, I promise. We were talking about preliminary versus grand jury.
Mhm.
So when we're looking at the preliminary, I guess going to the judge, I guess, and
Mhm.
you say that is when it's against the state, when the state is the victim.
Yes.
And am I to assume that the grand jury is when there is a person that's the victim?
My apologies. I forgot to mention that. Yes. So if there's a specific person that is the victim of a crime, such as an assault, a robbery, rape, was whatever the case may be, and there's an actual victim, the point of the grand jury is that they don't want to re-victimize the victim by putting them on the stand in a prelim, because in a preliminary hearing, they're going to put the victim on the stand. So in order to alleviate that, they decide to use a grand jury. So yes, to answer your question, yes.
Okay, good.
I have it might be a comment more than a question.
Sure.
In some regards, it's just seeing if I'm thinking through things right. So I'm just thinking time frame for someone. So say, someone is arrested. It could take 24 hours first for the initial judge appearance. And then they're going to have the trial and arraignment.
Mhm.
And they get to either plead guilty or not guilty. And if their bail is for some reason set very high, or the judge says that there is going to be no bail in this case, they could wait for a couple years, a year or two, for the trial. I mean, and to me, that's a lot of time. And if I was innocent, I would still think about pleading guilty because I would lose my job. My wife wouldn't be able to support. I do part of my support for my wife if I had a kid. Like a lot of this seems to kind of push people to take a plea deal, it looks like. But that's
So
kind of a comment. That's my
no,
opinion.
for sure. So keep in mind, spending that much time in CJC is an extreme example.
Okay.
It happens. I don't want to say rarely. I can't speak for that. I want to say it doesn't happen as often. And it is only for very serious crimes. And I would imagine that the state would argue that you would have to articulate to a judge why this person should be held. We can't just say, oh, we charge him with this crime. We want to deny bail. We want him to sit. He's a danger to the public. Well, you can't just say that. You have to tell a judge, well, he allegedly broke into the victim's house and shot and killed the victim based on this evidence. You know what I mean? Like they have to justify that, like completely denying bail, versus allowing them to bail out. So even for serious crimes, sometimes they won't deny bail, but the bail is pretty high. So if they can afford it, which I depending on that person's financial situation, I doubt. They technically could be released if they can afford it. But those to spend that much time in CJC is an extreme example. But it's not impossible. It can happen. I've heard stories of people being there for 2, 3, sometimes 4 years on a murder case. So
Thank you.
does anyone else have any questions? Okay, well, that's my time. If again, I'll provide this presentation to Nicole and she can provide it to you guys. And if I need to provide details, I can on what's in it. And again, if you have any other questions later, you can. I'm at the academy, so you can just come find me. So, okay, thank you.
Thank you.
Thank you.
We have a second training scheduled now, correct? Right?
Yeah, I believe so.
That's my understanding.
Yes, you do. And Nicole Barton, Nicole? Nicole Martin, will you be introducing the second trainer?
It may be in a different meeting. I know there's two different documents on our email, so.
The other document
that's
for the
true.
training on the 20th.
Oh yeah, you're right.
Where did Nicole go?
I don't see her in the room anymore, Lou.
Can we use this time to take a quick break? Maybe 5 minutes?
Yes, you may.
Thank you.
Okay, I will. Everyone, it is now 5:35. I have just spoken to Nicole Barton. She informed me that Lieutenant Brown received a promotion. So therefore, the other training session will not take place this evening. The next training session will be on Wednesday, November the 20th at 5 p.m. And it will be a training session on see what it says. It says a conflict resolution by conflict resolution at that time. So we will be ending our training session for today. Lieutenant Brown will not be training this evening.
All right.
Thank you for your time.
See y'all
Okay,
tomorrow.
thank all you for your time as well. Thank you.